Great. So I am delighted to be here, especially as James mentioned, my first job as a lawyer was here in Baltimore, and my first apartment, actually my second apartment, we had a really terrible place in Charlottesville, but our first really cool apartment that we had was 3 blocks directly south of this law school, in the building where the Potbelly Sandwich Works, which at the time had a great view south. You could see Cal Ripken's legs under the arch at Camden Yards during the streak, and you could look east, and you could see sort of all the downtown. And then they built the Zenith in front of it, and then they built the Hilton in front of the Zenith. But it was really cool in 1997. Okay, so I want to talk to you about a single big idea, which is an idea that I call intellectual privacy. And it's an idea that I think can and should and must inform both the development of our law, our constitutional law, our statutory law, our common law, and also responsible business practices. So, to put it in context, remember these. How many people here have never used one of these things? Or I guess if there's students here, do not know what one of these things is. Has anybody never used a typewriter? Wow. Okay, so the old people are shocked, including myself. This is a typewriter, right? This is what you used to use to put words on paper. That's why we call, it typing. I am 42 years old, and I am just old enough that I wrote my very first term paper in like 7th grade on a typewriter. And I'm just young enough that I thought it was so horrific that I pleaded and cajoled and wheedled my parents into getting me a word processing software, Bank Street Writer, made by Broderbund for my Commodore 64, that enabled me to store my drafts and then revise them, and required me to, allowed me when I wanted to edit, not to use like a little special white paint you used to have to put on, and it wasn't a very good typewriter we had. It didn't have correction ribbon. But this is an important change, right? In our lifetimes, we've moved from analog communications and expressive technologies to digital ones, right? So we used to communicate using letters. We used to read the news on newspapers, paper newspapers, and we used to read paper books. Some of us still do read paper books, but in our lifetimes, these technologies have been supplemented and increasingly supplanted by digital versions, right? The email, the web page, and the ebook. When we think about the legal interests that are implicated by these technologies, we often think about freedom of speech, right? The ability to express ourselves. And these technologies have had a tremendous effect on expanding the availability of free speech and access to the world. Travis talked about this morning to lots of people. But they also implicate privacy, right? The Bank Street Writer that I talked about created a record of my draft that was stored. It was very hard to send, to transfer data on a Commodore 64. You could record it to an audio cassette, and you could give the audio cassette to your friends, and they could put the audio cassette into their tape drive. Disk drives came somewhat later. But these technologies, the email, the ebook, the website, expand opportunities and access, but they also expand the potential for tracking and recording of what are very intimate and important political, sometimes, ideas. The old people in the audience will recognize this cartoon. This is from the early days of the internet, right? On the internet, nobody knows you're a dog. The idea that the internet was this totally anonymous space where people could express themselves and nobody knew who you are. This was before ad networks. The New Yorker ran a revised cartoon a couple of months ago. Remember on the internet when no one knew, right? The idea that no one knows you're a dog is a joke now because of the pervasive tracking of web surfing, the scanning of emails, the monitoring of everything we do by ad networks and by the NSA. This is a story about technology, but it's also a story about human values and how we can and should and must get our human values into the technology. The book talks about 2 ideas. The first idea, and this is something that Daniel Citron has also written about, when free speech and privacy conflict, free speech should usually win. I'm not going to talk to you today about revenge porn, though that's when the privacy should win, or about coverage of celebrities. I want to talk more about a second idea, which is that free speech requires something I call intellectual privacy. So what I mean by intellectual privacy is the protection from surveillance or interference when we're engaged in the process of generating ideas, thinking, reading, and speaking with our confidence. The point of intellectual privacy is that we can have all of the anti-censorship rules we want. We can have the broadest protection for speech, for lawyer speech, for antitrust, for commercial data. But if we're being monitored when we're figuring out what we want to say, something very valuable is being lost. And if we can't come up with anything interesting to say, if surveillance of our intellectual activities is being chilled to the mainstream and to the boring and the inoffensive, all of the anti-censorship rules in the world aren't really going to give us the kind of robust, diverse, vibrant, sometimes messy free speech culture that we want. There's two claims here, right? First, that intellectual privacy matters. Essentially, you're either with me or you're not on that normative ideological claim, that if you think that we should have zones where we can make up our minds about the world on our own terms to figure out what our beliefs are about matters as diverse and fundamental as politics or sexuality or religion or truth or beauty. If I haven't convinced you already, I'm not going to convince you. There's a second claim, though, which is an empirical one, which is that surveillance chills intellectual privacy, that when we are being watched, we act differently. We have a lot of cultural intuitions, Orwell's 1984 being the most famous of them, that when we're being watched, we act differently. There's also some empirical evidence. This is my favorite study in the history of social science. It comes from the University of Newcastle, psychology department, where they drink a lot of tea. And they found that if they had a sign that said, please put 20p in the box to cover the cost of milk and tea, if they changed the background of the sign to eyeballs, people gave more money, right? The idea that when you're being watched, you act differently. And sort of the scary eyeballs in 5, and also number 1. If there are any soccer fans, I believe that's Pierluigi Collina, the referee who had alopecia and sort of reffed a lot of very important games. One of my colleagues at WashU has also found that when you monitor employees at Applebee's using information technology to deter theft, they steal less money. And that's good, right? When it comes to things like theft of money from the till, maybe even failure to properly chip in as being a good sport with your share of the tea money, these are bad behaviors we want to possibly deter. But in a free society, when it comes to truth, when it comes to ideas, when it comes to belief and conscience, there is no such thing as a false idea, no such thing as a bad idea. Individuals must be free to figure out for themselves what those bad ideas are. We found, I wasn't involved in this study, but scholars have found that the Snowden revelation chilled people's willingness to search for controversial topics. Yes, topics like bomb making and jihad and Ayman al-Zawahiri, but also things like abortion, weight loss, divorce lawyer, tingling sensations on the palms, right? Sort of medical, or am I gay, right? All of these things that were deterred, even things that weren't illegal, things that maybe were just a little embarrassing or sensitive. When we're watched, we act differently, and we have this idea of a chilling effect, right? That I hope these snowmen don't come to my house. But we have this idea in First Amendment doctrine that if a value is so important, we don't require the same level of rigorous proof in order to protect. And I believe, given its nexus to freedom of speech, and really the values that undergird the First Amendment, and by extension free societies, we don't need the evidence. Some of the consequences of intellectual privacy can themselves be chilling. We found out from Edward Snowden that the NSA was surveilling radical supporters of jihad, not terrorists, not members of Al-Qaeda, not people loading bombs into backpacks, people who merely shared a political belief with some members of the radical jihad movement. And they identified, these are declassified Snowden documents, that they found out that a lot of jihadi radicals liked pornography, and that they monitored their porn habits with the idea being to publish them and to neutralize them through sort of an info war, to degrade their loss, to degrade or lose their moral authority. This is one of the spreadsheets. You see people like lawyers and clerics, radicals, celebrities, critics of U.S. policy, U.S. people as well as foreigners, and you may have a particular image in your head of what kind of person that is. I think of this guy, who himself was monitored by the FBI because they believed he was a communist, and that's why he was trying to destabilize the South. It turns out he wasn't an agent of the Comintern. Martin Luther King honestly believed that he should destabilize the politics of the South because it was a deeply oppressive racist regime. The FBI found that he wasn't a communist, but that he was very friendly, and that he was having a number of extramarital affairs, and they sent him the photographs along with a note suggesting he should do the honorable thing and end it all in order to avoid his family and spare them the embarrassment. Let me talk briefly about three special areas in which I think intellectual privacy is important. The first is thinking. What is this girl thinking? Well, we could ask her. We asked my son, and he drew this diagram of the things that are in his mind. That my favorite part is between awesomeness and screaming is stupidness, a very small amount of stupidness. But really, when we use Google, we are thinking. We are thinking with the aid of technology. Think for a moment about everything you've entered into Google's search bar. Then think about what would happen if your professor, your spouse, your boss, your judge, all of us were to be able to see that. Would you search differently? Would you be deterred from exploring ideas? Google themselves recognized this fact. Their slogan for Chrome when it released was to browse the web as fast as you think. Searching and browsing is, in a sense, thinking. Reading, too, is important. What is she reading? Well, she could have been reading this. In fact, one of the reasons that 50 Shades of Grey succeeded in the market was because of the prevalence of electronic readers, which created an illusion of physical privacy. No one knows from the back of a Kindle what you are reading, and so you can read it, as A.L. James's publicist said, on the tube. However, Amazon knows. Amazon knows everything you are reading. They know your library. They know what page you're on, how long it takes you to finish a page. They know what passages you highlight. They know how many times you've read, or even in the case of this book, perhaps reread, particularly juicy or salacious passages. And what's truly shocking is this is unregulated in most jurisdictions by statutory law. Videotapes, and by extension, DVDs, Blu-ray, and even streaming services, movies and TV are regulated by federal law under the federal VPPA, which was passed after Robert Bork's really rather boring video rental records were published by the Washington City paper, but we don't have the rule, these protections for books, and that's important. I have to be equal to my children. I told my daughter, who is 11, the book I was writing is about over breakfast one day. She said, I think intellectual privacy is very important because that way me and Declan, that's her brother, can read inappropriate books. And I love that phrase because reading inappropriate books in an unfettered way is exactly what the First Amendment should protect. It is exactly what living in a free society is about. Let me talk about confiding briefly. This is Roy Olmsted. He's the bootlegger from the Pacific Northwest, also a former Seattle area police officer, whose bootlegging in the Olmsted case led to Louis Brandeis's dissent, which ultimately led to the reasonable expectation of privacy test, which protects phone calls. This is Smiling Bob. You may remember him. He was on TV when I lived in Baltimore. He was the avatar of Enzyte, the natural male enhancer that made him smile so much, put forth by Berkeley Nutraceuticals, clearly a responsible company. They were investigated for fraud and making fraudulent claims, which has other interesting First Amendment issues that other speakers have talked about. But the Court of Appeals in the Warshak case held that emails are protected by the Fourth Amendment. This, however, is an open question at the level of Supreme Court doctrine. It's highly controversial, and I think we need to be sure that we bring our digital technologies within the scope of the Constitution. The Supreme Court has hinted in the Ryla case last term that it is getting there. So quickly, what should we do? We need to protect intellectual privacy through law. We need to realize that intellectual privacy isn't, this is Woody Hartzog's kids, isn't just for intellectuals, it's for everybody with an intellect, it's for everyone. We need to realize that intellectual records are sensitive records. We need to reject the idea that privacy is either its binary is either known to me only or spread to the world. We need to recognize the importance of protections for things like confidentiality with intellectual records, but more fundamentally, we need to think beyond law. We need to develop a professional ethics that protect intellectual privacy at the level of companies. Google's "don't be evil" promise, not always observed, but is a good step in the right direction. We need to refer to examples like librarians who have developed information ethics and have actively promoted the protection of those ethics through legal safeguards. We're starting to see some companies compete on intellectual privacy, right? The Mozilla web browser, Explorer should do this, has a series of pro-privacy principles, including sensible settings and limited data collection, as well as no surprises. And you see web browsers like the DuckDuckGo service not engage in finely grained individual tracking in order to provide search results with good results. Basically, companies need to stop marketing surveillance as a service. They should start marketing privacy and confidentiality and security as a service. So a final point, one of my favorite novelists, the Anglo-American novelist Zadie Smith, has argued in her review of the Social Network movie that in the Anglo-American world we race ahead with technology and we hope the ideas will look after themselves. I think that's an essential point, and we need to develop the sorts of ideas and values that matter and build them into our laws and build them into our technologies, and I think one of those values that we should protect is intellectual privacy. Thank you.